All right, video 9, part 3 of the King's Prerogative. What I've done here, as I mentioned in video 8, is now I'm going to divide pre-1688 versus post-1688. So essentially the arbitrary power against the constitutional power that occurred after 1688 and sanctified through the Act of Settlements. So what I asked AI to do now was make that division based on those 6 subcategories we went through. And we were speaking from Book 1, Chapter 3 of the King and his title. So beginning with that, what we got here? Now I'll go right to the end. So the conclusion of AI going through that summary, it stated, while Blackstone doesn't explicitly label any powers as despotic, he frankly contrasts the unchecked authority of earlier monarchs with the constitutional limits established post-1688. His work champions the balanced sovereignty that emerged from the Glorious Revolution, marking the transition from arbitrary rule to a monarchy governed by law and consent. So starting from number one was with regard to his title. So before 1688, sovereignty was often seen as divinely ordained, with the monarch ruling by divine right and enjoying largely unchecked power. Hereditary succession was absolute with limited parliamentary oversight. After 1688, the monarch's title is subject to constitutional law, particularly the Bill of Rights, 1689, which established parliamentary sovereignty and curtailed arbitrary claims to the throne. Succession is no longer solely divine, but contingent on adherence to law, such as Protestant succession under the Act of Settlement 1701, which essentially, no longer can anyone of the anyone of the Catholic persuasion can ever sit on the throne. Number 2, his royal family. Pre-1688, the royal family's position was largely sacrosanct, with few constraints on its privileges or the conduct of its members. Their role was primarily dynastic, ensuring continuity of royal power without significant public or parliamentary accountability. Post-1688, the royal family operates within a constitutional framework. Blackstone notes that its privileges are now defined and regulated by law, ensuring their role supports the monarchy's constitutional function rather than unchecked authority. Number 3, his councils. Before 1688, the King's Council, such as the Privy Council, acted primarily as instruments of royal will, often enforcing policies without parliamentary approval. These councils could wield significant arbitrary power under despotic rulers. After 1688, councils became more accountable to parliamentary principles. Blackstone highlights their advisory role in a constitutional monarch and which decisions made in the context of collective responsibility and adherence to the law. Number 4, his duties. Pre-1688, the duties of the sovereign were often secondary to the exercise of power, with rulers prioritizing personal authority and prerogative over service to the realm. Accountability was minimal, and the king's interests often overshadowed those of the public. And post-1688, the king is positioned as a servant of the state, obligated to act in accordance with the law and to prioritize the welfare of his subjects. Blackstone underscores the shift to a government of law rather than personal rule. Number 5, his prerogative. Before 1688, prerogative powers were vast and often unchecked, allowing monarchs to legislate, tax, and administer justice. This was the essence of despotic rule, where the king could act outside or even against the law. Post-1688, the royal prerogative is significantly limited by law and parliament. Blackstone identifies this as a critical safeguard against tyranny. ensuring that prerogative powers are exercised within the constitutional framework and primarily for the public good. And finally, number 6 is revenue. Pre-1688, the sovereign relied heavily on hereditary revenues and can impose taxes or levies through arbitrary power. This lack of accountability was a hallmark of despotism. Now, post-1688, revenue systems are constitutionally controlled. The crown is now dependent on Parliament for extraordinary revenue, ensuring transparency and accountability. The Civil List Act formalized this arrangement, limiting the monarch's financial autonomy. Now, even if we went into the idea that he had all this power, he still had to run them through those minds of the time. I mean, taxes were never favorable. And that's what we'll come to realize in 1535 when King Henry VIII's purse was starting to run a little dry. Instead of looking towards adding a tax, he went right into land and wanted to make sure that to now gain control of those tenures, because there was too much usages going on and too much land that he used to rely on for revenue being moved over into trustees, and therefore the common law could not have a right to control that interest because now it was under the guise of rules of equity. So with that short video, great. We will move into, I'm not 100% sure yet. I'm entertaining a couple of ideas, whether we should look into persons or touch in a little bit on a bit of reversion remainder, only in as much as to give us a point of the evolution from the Magna Carta, 1215, which was, I know a lot of people, or not a lot of people, there was people trying to use that as a means in which to identify as a constitution, which essentially has nothing to do with you or even citizenry, because citizenry weren't subject to common law, and that was a act that was instilled for the rights to barons and lords to exercise, not for those who were villages and copyholds, those who didn't have a right in common law. So Magna Carta is not the go-to. But also from that point, went along with that, we want to move into law mortmain, but more specifically into Quia Emptoris of 1290, Edward I, whereby now we see the first movement into tenants having actual power to control an interest that they hold in land, which essentially is the true beginnings of fee simple for the tenant. And with that, hit that like button. Don't forget, if you like or not like, and subscribe if you haven't done so. Talk to you soon.